Good afternoon. Thank you for attending today's program. This is Beth Overmo. I'm the Strategic Plan Coordinator for the State Bar. Just want to take care of a couple of housekeeping items before we get started. Typically, the presentation lasts about 45 minutes, maybe a little longer, and then we leave some time at the end for questions. So you will have the opportunity to submit text questions for today's presenters by typing your questions into the chat pane or the questions pane on the control panel. You may send in your questions at any time during the presentation. I will be collecting them and address them during the Q&A session at the end of today's presentation. And with that, I will turn it over to one of our presenters, Cameo, to kick us off.
Thanks, Beth. So my name is Cameo Anders. I'll introduce myself in a second. Just wanted to sort of present this topic, the efficacy of advanced care planning during COVID-19. You know, as we think about cures and vaccines and, you know, the efficacy of kind of the pharmacological issues. Another issue to think about, which we'll be doing today, is the efficacy or the effectiveness of our powers of attorney and our living wills, and then also these transportable medical orders, Comfort One, Most, and DNR. So as we get into that, quick introduction. I am an attorney here in Sioux Falls. I also sit on the ethics board and IRB board for a hospital, and am a faculty member for the ethics section with USD. And I sit on the Life Circle, which is the parent group of the Most legislation that we'll talk about really briefly. Just a disclosure, you know, I do not represent any of those entities here in our conversation. We'll be talking about different legal aspects, and as you know, all of you attorneys are aware, this is just for purposes of education and not legal advice. I'll turn it over to you, Tom.
Hi, I'm Tom Simmons. I'm a professor at the University of South Dakota School of Law. Prior to that, I practiced law in West River, South Dakota. I'm a lifelong South Dakotan and a South Dakota attorney, and my focus in academia is estate planning and matters that include things like healthcare powers of attorneys and living wills.
Thanks, Tom. So quick outline for us. We're going to be talking about our estate planning and why it should still continue to be a high priority during this time of pandemic. Then we'll talk about our powers of attorney and our living wills and how they could be overridden by subsequent client direction, the Comfort One and the Most document, and then just briefly DNRs as well. We'll see, thirdly, the Comfort One and Most, they could be created by an authorized surrogate. So we also want to have a really good understanding of who our authorized decision makers are for our clients. Fourth, artificial nutrition and hydration versus life-sustaining treatment. These are the two areas that we address in our documents. So kind of an understanding what are those areas and maybe what are their limitations. And fifth, applying that to our present situation. So getting started, I start with you, Tom. You kind of gave us a humble introduction, but you really are, in my mind, kind of one of the front thinkers on these issues of advanced directives. So I stole some of your language here. In our amended emergency order that came out for, I believe it was the April 19th, they spoke about living wills and wills and the ability to notarize and to witness. Tom, would you say, or would it be fair to say that witness by communication technology rule in that order also could apply to the powers of attorney?
Yes, so the Supreme Court emergency order does specifically speak to wills and also living wills. Within the wills execution statute, there's the term conscious presence utilized, and the emergency order clarifies that at least insofar as when the emergency order continues to be in place, that is defined to include communication by remote means such as Zoom and GoTo connections and those kinds of things, where an audio and a visual link is available that allows the witnesses to see the testator sign the document. The emergency order also speaks to living wills in terms of the witnessing of those documents. There's a form living will provided by statute that most attorneys are familiar with, and within the form it utilizes the word presence. It doesn't say conscious presence, but it says presence. So there was also a concern about whether presence would include communication by audio visual means, and the emergency order clarifies that it does, that a Zoom executed living will would also be valid. The emergency order doesn't speak to healthcare powers of attorney, and the thinking with that is that there is nothing in the statute and there's no statutory form that suggests conscious presence or even presence, and so that it wouldn't be necessary to also have the Supreme Court speak to the way in which healthcare powers of attorney could be executed remotely, because that's already implied by the way the statute itself reads.
Okay, thank you. So with that, I create powers of attorney for my clients, and I want to say that I want every client out there to have a healthcare power of attorney. It's going to appoint an agent who then can make decisions when that client becomes a patient, when they become incapacitated. And so I would really like everyone to have that document. But then whether or not they have a living will, in my mind, kind of depends on the stage in life that they're at. So if I'm creating an estate plan for a younger couple who maybe just had their first child and they're super healthy and they're in their, early 30s, to create a living will for them, which then might not pop into effectiveness for 40 years down the road, I'm going to be really hesitant that might be a useful document, or that they'll be in a place where they can make those informed decisions. But I know that some people disagree with me. Actually, maybe lots of people disagree with me. So would you, Tom, agree that everyone should have a power of attorney? And would they also need a living will at the same time? Or what would your thoughts be on that?
It's an interesting question, and my response to it has kind of developed as we prepared for this webinar today, Cameo. I mean, I had always taken the approach that clients should have both a living will and a healthcare power of attorney. The living will is a very narrow document, just speaks to the kinds of life-sustaining treatment, if any, the individual would want in the event of a terminal or vegetative scenario where they can no longer communicate with their physician. The healthcare power of attorney applies much more broadly to any healthcare decision. And so arguably, if you vest your healthcare agent under a healthcare power of attorney with all powers, including the power to deal with end-of-life care decisions, there's really no additional need for a living will. The reasons, I guess there's two of them that I have always thought that a living will was nevertheless still recommended is twofold. One would be that you could run out of agents. You could typically appoint a primary agent and then at least one backup. And if both of those two individuals with whom the principal is probably close are in the same accident, for example, all of the agents named are disqualified because of death or incompetency. And in that event, I would still want the client to have exercised their autonomy the way that they would like to indicate what they would want for their end-of-life decision. And they could do that in a living will that would apply even if the healthcare power of attorney no longer did because of the lack of any further agents to act. The second reason I think that I've always thought that a living will was a good addition to a healthcare power of attorney was, when we're drafting for an audience. If you're drafting a brief, it's for the judge. If you're drafting an article, it's for the people you think are going to read the article. We're drafting these documents primarily for healthcare workers, primarily for non-attorneys. And so as you think about that, I guess one of my concerns would be that if a person goes into a hospital and the healthcare providers say this person has a healthcare power of attorney, but they don't have a living will, that they might interpret that to mean that they don't have any provisions that relate to end of life decision making. And so by simply at least allowing the healthcare providers to check that second box, they also have a living will, I'm keying them into this person has exercised their autonomy and set forth what they would want in these particular situations. And I'm worried that that might get misinterpreted if they don't have that additional document. You know, you look on the back of your driver's license, and I think there's two boxes that are checked, Y and N, whether you have a healthcare power of attorney and also whether you have a living will. And checking a no for a living will might be interpreted in a way that would be inconsistent with what my client's objectives are. As we've talked, I've kind of further developed that thinking, and now I have additional hesitations about using both. But that's always been my approach to justifying why you should have both.
Okay. Yeah, thank you for that clarification. I think I would agree with you on all of that. And then I like, just keeping those hesitations in the back of our mind as we move forward, because I think as we look at how COVID-19 is going to apply to our advance directives, it mostly would affect those living wills. And so let's move forward, but come back to that a little bit. So this slide here that you're looking at just kind of lays out 4 documents to think about today: the powers of attorney, the living will, and then how I say they could be overridden by these subsequent comfort one or most documents. So we really want to know which document is going to control our client's wishes. And we as attorneys, we draft the powers of attorney and the living wills, but then the comfort one and the most are documents created within healthcare. And so being aware of, the conversations that our clients are having with their healthcare providers and the conversations that we are having with our clients, they really should all form one kind of connective, puzzle is probably the wrong word, but one big picture that works well together. Tom, can you just briefly tell us about living wills and durable power of attorney, just their distinctions?
Sure. And living will is always, I think, the worst named thing in the entire world because it sounds like a living trust and like a last will and testament. And it's typically done in connection with those documents, and so it's very confusing for your clients to assess what they have. They'll come in and say have a living will, and it just means they have a will or something other than they actually have. So a living will, I had a partner, Pat Getzinger, where I used to practice, who would say that the living will is the show horse and the durable power of attorney for healthcare decisions is the workhorse. And the rancher clients really like that distinction. The living will is a very narrow document. It says, in the event that A, I'm either terminal or vegetative, B, I can't communicate with a physician, and C, I've got some artificial means of life support that is only sufficing to maintain me and is not going to cure me or improve my condition, then in that situation where all 3 things are lining up, then I direct the following, and the person can direct either to keep things going or to withdraw them. The durable power of attorney for healthcare decisions is tremendously broader than that, and typically does not include specific directions, but just like a financial power of attorney, lists powers that your agent, or sometimes we call them your proxy or your attorney in fact, can exercise in connection with the principal's healthcare. Once again, this is only effective when the individual himself or herself can't communicate with their physician, and in that event, then you have this surrogate decision maker who is vested with the powers of agency to obtain information from the healthcare providers and then make informed decisions on behalf of the incapacitated agent.
And our state law tells us that the last created document, or the most recent of those 2 documents, is the one that is effective. It's the one that's powerful. And so if we first create a power of attorney and we address artificial nutrition and hydration and say we want all of it all the time, in whatever means, whether that's through the nose or through like a stomach insert. If we create a living will after that, and it says something opposite, it says no artificial nutrition and hydration, then which one is going to be the effective one?
It's the most recent document, which we would assume, I think correctly, is a better reflection of the person's views with regards to how they want to receive health care. It's closer to a point in time when they've lost an incapacity because it's a more recent document.
Okay. Yeah, and then there's kind of this weird part of our law that says in the living will statute, if the living will is created afterwards, then that is the effective document, but it doesn't mean that the agent can't still participate. So in my mind, if we create a power of attorney and a living will, and the living will is that show horse, maybe we create them at the same time, or if we create the power of attorney first and then 10 years later, the client has been thinking more about what they really do want. Maybe they've been diagnosed with cancer, or they're thinking about these end of life issues, and they create that living will, just also being aware that that agent in the durable power of attorney isn't automatically shunned. They're not automatically like kicked out of the equation, but can still have a participatory role.
Right.
Let's move into, we talk about Comfort One and Most. So some people may have heard of Comfort One. It's that, if the EMT comes to the house and someone's had a heart attack and they don't want to be, they don't want cardiopulmonary resuscitation, then the EMT are legally safe not to perform anything, but to just provide comfort for this person if they have a Comfort One bracelet. So that Comfort One is a medical order which transports. Usually medical orders only are valid within the medical facility that the doctor, or in this case it could be a physician assistant or a nurse practitioner, where within that facility where they have the right to practice. So this Comfort One sort of transports out of the facility to wherever the patient is. And so we have these other new transportable medical orders called MOST, Medical Order for Scope of Treatment, which sort of expands Comfort One to include everything that a living will could include. So we'll talk about MOST more at the state bar coming up in June here. So I won't go into it a whole lot, but if we think of it as an expansion of Comfort One that addresses everything in the living will, so it's sort of an activation of the living will. If I have a living will or a durable power of attorney and I go to my doctor, the doctor has to look at that and then create a medical order that sticks in my chart. And that medical order is limited within the four walls of the healthcare institution. If I have a MOST, which then is only able to be created when I have a terminal condition and death is likely to occur within 1 year. So notice it limits the living will by a little bit, saying if within 1 year I'm likely to pass away, now I can make my living will instructions into these transportable medical orders. And so MOST is intended to image or mirror the living will. And Comfort One is intended to sort of activate a DNR, which usually we don't talk about DNRs in our living will. So I think Comfort One is probably less useful than the MOST document. But on this slide here, I created these white dots. If each of these white dots were a point of medical attention for a client, then every time they go in and get medical attention throughout their life, they have to have another medical order. At the end of life, where they're likely to die within 1 year, the MOST document can just be a medical order that continues to apply for that 1 year, and they don't have to have, a white dot every time they come in. So I'm not sure if I'm making myself super clear, but think of the most as that like activating agent of our living will. Tom, do you have anything you want to add to that?
No, I think that makes a lot of sense, and it's interesting because both the most statutory chapter and the Comfort One statutory chapter are critically important for our clients. That's when things that we've drafted and discussed actually start to get implemented by physicians with their patients. But they're not anything that we ever directly really deal with unless we're advising a hospital or a healthcare provider because they're medical orders. So in other words, I guess maybe it goes without saying, but us attorneys, we don't draft medical orders. That's up to the doctors. And so both of those paradigms are chapters in which we will have very little involvement, but they're also critical to understanding exactly how our documents will work.
Yeah, good point. And I think what I have seen is if I've created a durable power of attorney for a client and they've, let their agents know about this power of attorney, the problem with the most, which we don't draft, but the problem that I think we as attorneys want to be aware of is if I appoint or if my client appoints an agent, then that agent, and if so let me reverse here. With the most, the patient or the client is the one that creates the most for themselves. They say, this is what I want, and you can activate it because I'm now within that 1 year time limit. But if the patient client lacks capacity, then the statutory language in the most is that an authorized representative could also create the most. So I really want the authorized representative to be the agent under my power of attorney. We don't exactly have that statutory language, but the education that the medical field is doing does. So I think we're safe there. But if for some reason let's say one sibling was the agent under the power of attorney and the second sibling created a most while that person was gone and the medical field didn't know about the power of attorney, maybe it wasn't in the record. So we'll look at a minute, there's a pecking order, and we'll look at that in a second. It's possible that there could be some confusion with who the authorized person is under these documents. So I think as attorneys, we really want to know, here is your agent, here is the person who should be making these decisions, so that if our client or if our client's agent comes back to us, we're aware of how these medical orders work. Because you're right, we're not creating them, but we might be asked about some of the confusion that could come up with them. This slide here is just kind of showing the overlay. Ideally, that most is going to overlay our living will and our power of attorney, if depending on the documents that we have. Tom, any other thoughts on those 4 documents just before we move forward?
No, the only thing that I would emphasize is that if you've been to an emergency room lately, they will ask you whether you have these 2 documents, either a living will or a durable power of attorney. And your clients will get asked that if they go into the hospital. And if you want the documents that you have put together for a client and gone over and discussed and fine-tuned and so forth, if you want those to be enforceable, you really have to ensure that your client either carries those documents with them all the time, which is probably not feasible, or that they pre-file them with the hospital so that the hospital doesn't ask them to sign new ones while they're on the gurney trying to get health care.
Yeah, good point. And I can't remember whether it's what it is that has been enacted recently, but the healthcare providers, they have to ask that question. Do you have an advance directive? And if you don't, they're going to ask you every single time you come in, whether it's, if you were just in yesterday and now you're, in for a follow-up, they're going to ask you that question again. So I think there's some disagreement as to where your clients should keep those documents. But Tom, you're right. If you give them to your medical provider to keep in your medical record, then they'll stop asking. right? And
Right.
also, though, with that, if you change anything, be sure that it's changed in your medical record. If you change agents, if you change, what you want done with life-sustaining treatment, just be sure that that change gets noted in that record so that they have the updated copy.
It's almost as important as filing a deed, I think. When we draft a deed for a client, we'll absolutely file that with a register of deeds. I think a lot of times when we draft these documents, we just send out the client with the documents, and we should really think of them almost like a deed. They have to get filed if they're going to be honored. Otherwise, they'll just be unintentionally revoked when the hospital insists that they sign one as they come into the hospital.
Yeah, good analogy. So we've talked a little bit about, we want to know what's the controlling document. We've seen that the latest document created, or the most recent document, is going to be the effective document. So with that, that includes the comfort one or the most. If I have a living will created with my attorney that says do A, B, and C, and then an authorized representative. So for a minute, let's say I don't have a power of attorney and I didn't appoint an agent, and I have 4 children. So if I have a living will and I'm in the hospital and I lack decision-making capacity, and my children are great, but let's just make them, completely disagreeable with each other. Each of those 4 children could create a most for me, and each of them could say something different. And the last created one is going to be the effective one. So I really want to appoint a decision maker. I really want to say, okay, here are my controlling documents, and now here's my controlling decision maker, so that I don't have this fight between, surrogates on who gets to decide and who knows best what my best interests were. So as we look at this slide here, it has the pecking order, I call it, of our state statute. The Healthcare Consent Act gives us a pecking order which isn't normally controversial or conflicting. But notice if we get into that second category, an adult child, it doesn't say the oldest adult child or the adult child who's been taking care of mom for the last 10 years, or the adult child who's most reasonable. So all adult children can fight and have equal authority to do so. So I really want to say that make your power of attorney, appoint that decision maker in order to really clarify, especially when we get into these end of life issues, who knows the patient best and who can speak on their behalf. Tom, do you have any disagreements on that or any insight?
No, I think this is really important too, Cameo, and I think it's not uncommon for attorneys to not spend a lot of time on SDCL 3412C, but it's essentially an intestacy statute for healthcare decisions. So if the hospital isn't aware of the healthcare power of attorney document, or they don't have one, or all the agents can't act, all at once you do have a hierarchy of people vested with the legal authority to make healthcare decisions on behalf of your client.
Yeah, and hopefully they agree and know what you want, but likely they won't. So talk to your attorney and create your documents, right?
Right, absolutely.
So I want to take a quick tangent here and go to informed consent. We think of that in other areas of the law, but mostly with healthcare decisions, it really becomes prominent because a person, in order to have a medical provider do anything, the medical provider needs informed consent of that person. And so we've seen informed consent statutes. I put our South Dakota statute in here, this 3412H16. We see that it needs to be voluntary and knowing and competent. We also have this informed consent that comes from the Belmont Report, which applies in large part to human research trials. So if we think back to Nazi Germany and all of these human research trials that were going on in the concentration camps, and how the world sort of revolted against that idea. We had the Nuremberg trials. Then we had this sort of effort to create ethical policies on how we could do ethical or good research that, you know, we could all acknowledge that human research is important for medicine, but we really want to make sure that the person being researched on is not being used just as a guinea pig. So we get this Belmont report. Then we get a big effort. That's the wrong word I'm using, but it's, if we look at the history of informed consent, it used to be that the physician decided that the patient got enough information. So it was a reasonable physician standard. Now it's a reasonable person standard. What does the reasonable person want to know in this situation? And also a subjective person standard in the sense of, what does this subjective patient need to know in this situation? So it's a high bar that's set for medical providers to attain when they're trying to attain informed consent. And I feel like when we look at our documents, the question is, are we having our clients make decisions, make clinical medical decisions, such as those in the living will? And if so, are they ready to give informed consent? Are they knowingly making the decision to not have any life-sustaining treatment? You know, or are they at the beginning of their 30s just starting a family and they're like, oh yeah, when I'm old, I'm not going to want tubes, so let's just categorically deny all life-sustaining treatment. You know, is that an informed consent decision? And if not, I just want to go back to that hesitancy to create the living will. Is it a good time for this client to be making these decisions? Are they doing so with informed consent? And are we the people to help walk them through that? I don't have answers to that. I think it's going to be kind of circumstantial. You know, if my client is 80 years old, yes, I can help walk them through those issues. But if they're 30, maybe they're not ready to walk through those issues. Tom, do you have any thoughts on how those conversations go with your client when you're creating a living will? Are most people having informed consent discussions?
I don't think they probably are. I think for most clients, the question is either framed or received as simple as, if things are hopeless, do you want them to pull the plug? And in my experience, the great majority of people will say absolutely yes, without really any interest in pursuing that further and looking at individual circumstances. I think almost any individual out there would want extraordinary means of life-sustaining treatment withdrawn when they were simply just not going to improve any kind of chance of recovery or comfort of the individual. And everyone would also want life-sustaining treatment even though things look pretty bad in other circumstances. And the documents don't really get into that nuance. And there's sort of a metaphysical question in terms of someone making a decision about their health care in the future now, kind of binding their future self. It's the same person, but it's also not really the same person a number of years later. I remember when I was 11, I swore I would never have a glass of beer because I knew someone that had gone through alcoholism and so forth. And boy, I'm glad that 11-year-old self doesn't bind me forever and ever, never being able to enjoy a beer now and then. That would be almost contrary to my own autonomy. And so it is really tricky, and I don't know how you get into a lot of really good discussions with the client when it's completely abstract. Most of them will simply say, well, I think, I'd want the plug pulled, and then ultimately if they can vest a really trusted agent with the authority to wrestle with the particulars of when that's appropriate, that's how it works effectively. But the living will standing by itself simply says, essentially, pull the plug or don't pull the plug. And the attempts to try to find greater nuance and say, well, if I'm really, really sick but not too sick and that kind of thing usually just creates more ambiguities than it solves.
Mm-hmm. Yeah, I would agree. So I have a colleague who is a palliative care physician, and And, she has made a comment that maybe someone in their 30s, would want one thing, but someone in their 80s, their autonomous self, like you're saying, is going to want something different. And how can you really respect the autonomy of that 80-year-old when you're 30? And so I think that's a really good point that you're making. Let's look at some of those, if pulling the plug, like what actually are the plugs that we're pulling? And our state law divides them into artificial nutrition and hydration, and then life-sustaining treatment. So we look at that on slide 13 here. We have no state law definition for artificial nutrition and hydration, but we have, if we think of artificial food and liquid or fluid that's going to hydrate, it could be through the nose, it could be through an insert, a more permanent insert into, an NPEG or a GPEG, so there's several ways that we could receive this artificial nutrition and hydration, temporarily or permanently. The life-sustaining treatment, we do have a state law definition, and it's really any procedure that is administered to postpone the moment of death. Even this definition here, it doesn't really tell us what we're talking about. So if we look at options for life-sustaining treatment, it could be a ventilator, or it could be dialysis if you have kidney failure. It could be as simple as antibiotics through an IV, or chemo if you have cancer, or oxygen. We have this sort of ambiguous category, and we can see just from this short list that these things address very different medical situations. So in my mind, it's going to be hard for me to have a conversation with my 30-year-old client to say, well, do you want a ventilator or dialysis? And I would almost have to be able to describe these medical conditions when a dialysis machine would be necessary, which I'm not qualified to do. So just kind of reiterating that hesitancy to create a living will and categorically deny life-saving medical treatment, or categorically refuse all of it when we don't really know what that category is. I say that, and this next slide here shows the most document that I think, so I've said that this was the document that activates our living will, and I think this document allows for an informed consent decision. This is the document that the physician or the medical provider has with the patient when they're in that terminal condition, when they've reached the end of life. Tom, do you think our living wills should be more specific, similar to this most document, or how can we remain in our legal bubble of professional advice while refraining from getting into discussing medical issues?
I'm against it. I think that if you start to try to map out the different scenarios where you would want suction but not cardiopulmonary resuscitation, you're going to end up creating a document that doesn't apply. It's just ambiguous as to whether it actually applies in a particular set of circumstances.
Yeah, and I've heard that it's not helpful to the medical field. So in my, I'm the only attorney sitting on a couple of those boards, and whenever we have a discussion about a living will that's not very helpful, everyone just, gives me daggers. So I'm going to make that recommendation as well. If we're not having an informed consent discussion with the client where they say, you know what, I know I have cancer, I know that I'm done with chemo treatments or whatever it is, if they're not at that point, then some of these decisions might be better left to medicine. And that's circumstantial. So I'm not saying don't ever create a living will, but having that, what kind of decisions are being made in the living will, I think is important to think about.
Right.
Just quickly going back to the difference between the ANH, artificial nutrition and hydration, and LST, life-sustaining treatment. Why are those separated in our statutes? I put in here the Quinlan case, just a snippet from it, that makes the distinction between the ventilator and how the ventilator and the removal of that isn't considered, killing someone. It's not considered euthanasia in any way, because the underlying condition of the patient is what is causing these difficulties. And so a removal of a ventilator under the principle of double effect is not causing death. The principle of double effect is the same one that justifies, the distinction between self-defense, defense of others, compared to murder. It distinguishes terminal sedation, when someone is in extreme pain and they're getting morphine, and that morphine is sort of depressing their respiratory system and hastening death, but not causing death. So the principle of double effect distinguishes that from like a physician-assisted suicide type of scenario. Our U.S. Supreme Court has looked at these cases and made this distinction. And so now in our state laws, after this Quinlan case, and then the next case being the Cruzan case, our state laws address these two things. The Cruzan case talks about how a removal of the artificial nutrition and hydration would be the cause of death. So they don't find that it meets the same principle. Tom, do you have any thoughts on the distinction between artificial nutrition and hydration and the life-sustaining treatment?
I mean, there's an ethical distinction, but I think a lot of times for the individual, there's not much of a distinction. There's the cessation of a particular form of medical treatment, and within a certain period of time after that's withdrawn, they die. I think it's also worth emphasizing, though, that the state statutes themselves do not even permit one to make an advance directive that results in the withdrawal of treatment that causes pain. So even if you were to create a living will, for example, that said, withdraw treatment even if it causes me discomfort, that's not enforceable under the statutes. Comfort and alleviation of pain trumps a desire to withdraw treatment when the patient has lost the ability to make their own decisions about that.
Yeah, good point. And there's, so you had a question for me, I'll bring it up here, but there's a section in our statutes that say comfort care is always, always provided. And like you said, you can't sort of draft yourself out of comfort care. And so anything that would cause pain, I think would be, you would need comfort care. You brought up an example of choking. And then if you have this, if you have a most document, or if you have a living will that says don't provide any care, do not resuscitate, do not intubate. The question then is, well, what if I'm in a terminal condition, so my living will is effective, or my most document, depending on what has been created. What if I have that underlying terminal condition and then I just choke and I pass out? And I think, and I've asked some colleagues as well, but that painful choking and passing out and not being able to breathe, that would always be comfort care. So regardless of our documents, we can't sort of opt out of those normal emergent medical treatment that we would get, unless it's very clearly written, like do not resuscitate in the event of a heart attack. So yeah, anything, even though our statute has given us a lot of freedom, a lot of autonomy to create our end of life care, there are certain things it reserves and says we will provide this no matter what. One other distinction with the artificial nutrition and hydration is, if we're looking at the digestive system, it hasn't shut down yet. And so if we don't provide, we have to voluntarily eat and drink. If we aren't able to voluntarily eat and drink, our statute presumes that somebody else should voluntarily give us food and water while our digestive system is still working. Whereas the law kind of treats, if your respiratory system is no longer functioning, we involuntarily breathe. And so if our body no longer involuntarily breathes, we don't need to go to those extreme measures to force it to breathe, such as with that ventilator. So we have this distinction, and I move into, here's our living will statute, which very specifically says we have to address the artificial nutrition and hydration, because if our digestive system is still working, we want to still give people that food and water if they're able to receive it. Here is our power of attorney statute, and it says the same thing, but I like this statute. It's a little bit more separated into saying, you know, if death is imminent, if artificial nutrition and hydration can't be physically assimilated, if the burden outweighs its benefit, and notice this is not like a quality of the continued life, like, oh, this person is old and they're kind of burdensome, or life is burdensome to them, but this is a physical burden of the treatment. If that's significant, or if there's clear and convincing evidence that the person did not want the artificial nutrition and hydration, if the principal, being our client, specifically addresses in the power of attorney what they want, or if they specifically authorize someone to make that decision. So when we create our powers of attorney and our living wills, we have to specifically address this artificial nutrition and hydration. And then we have to ask ourselves, you know, okay, client, is this a place where you could make this decision? And I think our state law gives us the ability to make informed decisions about artificial nutrition and hydration under these three categories. You know, anyone could think, okay, my death is imminent, I'm not assimilating this, and the burden is significant. Yes, I want it removed. If our clients aren't in that position to make those decisions, our statute gives us a really nice area, number 6, to just give them the authority to make the decision. So just noting that regarding the artificial nutrition and hydration, we're pretty regulated, but we're not really regulated at all about removing life-sustaining treatment. So I think that's a significant point to be aware of. Tom, do you have any, before we go into how, just in our last couple minutes here, how this pandemic affects those two documents, do you have any other comments?
No, I just emphasize, though, that all of these kinds of decisions always presume your client isn't making the decision anymore. Anytime your client is being asked, do you want artificial nutrition and hydration, none of this really applies. They're just making their own decisions about their health care. It's when they've lost the ability to make those decisions that these rubrics come into play.
Yes, exactly. Yeah, thank you for that clarification. And I think that was exactly the Cruzan case. The US Supreme Court said, we assume that somebody who's competent or has capacity can make these decisions. And the trouble is when a surrogate's making them for them, then what kind of restrictions do we want to put on there?
Right.
So moving into our COVID-19 and the effects on our state planning, I just put up a brief outline here, and we're coming to the end of our time, so I'll try to go through it quickly. But the first one, so when I say COVID-19, I'm referring to the coronavirus specifically, or the pandemic, or just in general, but I give you a site here to learn more about, you know, the different coronaviruses that are or have been out there. Regarding our estate planning, you know, if our living will is going to become effective, we need a terminal condition. So I think the first question is COVID-19 positive patient, is that enough to say, okay, you are in a terminal condition, your living will now kicks into place? And the answer is pretty consistently no. Those infectious diseases, even this one, which is, you know, causing significant amounts of death and not understood to its fullest, I think it would be a stretch to call it a terminal condition. So I don't think that the COVID-19 diagnosis itself pops the living will into action. But if a COVID-19 positive patient lacks capacity to make decisions, and if they haven't said anything, if they haven't put anything in writing, then that living will might serve as sort of evidence of what they may have wanted. So if we move into these next slides, why does that matter? So if a patient has a living will, they haven't appointed an agent to make decisions for them, then the living will, if that is, the evidence for what this patient wants, it probably will just categorically deny or require life-sustaining treatment. It probably won't specifically say, yes, I want a ventilator. No, I don't want a ventilator. Yes, make sure you give me antibiotics, but don't give me chemo. Or so we end up with sort of a and I think, Tom, you made this point, and I'll steal it and sort of mutilate it, and then you can clarify it. We end up with sort of this presumption that if there is a living will in place and we really don't know anything else about this patient, or they don't have an agent who's making decisions for them, there's sort of a presumption that maybe they don't want treatment. They have a living will. We'll is that a fair way to, is that a fair presumption to make?
Well, again, yeah, I think so. And I think, again, I'm trying to speculate on how the healthcare workers will be reading the document, and they're obviously incredibly busy right now anyway. But because most living wills do say, quote unquote, my quotes, pull the plug, I want to make sure that if that's not the directive, that it's really highlighted, because I'm concerned that patient A has a living will could get interpreted as patient A wants to withdraw all life support in the event of a terminal or vegetative situation where they've lost the ability to communicate.
Yeah. So once again, just bringing back sort of that hesitancy of the living will, not that we shouldn't create them, not that the patient shouldn't create them, but especially in this time, just being aware of what they say and whether they're effective. And in this time of overstressed and overworked healthcare providers, being really clear if the living will doesn't say, I don't want any treatment, just being really clear to highlight what you do want. I think that's a great point. So all of the states are creating these triage protocols, and this isn't something new. Like, we have military triage in wartime. We even have a sort of triage with organs in transplant. So with our organ donation, we have a scarce resource. How do we allocate it to the people who are most in need? And so during this pandemic, we have that same issue. We have a scarce resource of ventilators, or if we do find a cure and there's scarce resources of it, how do we make these allocations? We have scarce resource of hospital beds and protective equipment, and so each state is following these triage protocols or creating them, and they have exclusionary categories within them. So the Office of Civil Rights has put out a bulletin that very clearly says your exclusionary categories cannot be age, it cannot be disability, it cannot be these quality of life determinations. But it doesn't say anything about whether an exclusionary category could be, if your living will is effective, if you're in a terminal condition and your death is imminent, and you lack capacity and the living will says don't do anything, then the triage protocols don't give any guidance on, not including those with effective living wills, or those who have created a do not resuscitate, a comfort one, or a most. Do you think, Tom, that it's that if there was a category that said, we could exclude all people with most documents or effective living wills from these triage categories, would that cause you to hesitate?
Oh, it sure would. I mean, and that's the concern, I think, especially if we enter kind of a crisis in our healthcare system, that there'll be so many stressors on the healthcare workers and doctors. They'll be so overworked and so exhausted that they'll miss the nuances in the way a living will is supposed to work with the agent being really in charge of those decisions. And maybe the client would almost be better off without a living will at all, so that they're forced to communicate with the agent, and the agent can then visit with the rest of the family and so forth. I can see a scenario where an individual with a living will that gets kind of shortchanged on that full informed consent discussion with the surrogate would have wished they didn't have a living will. That's the concern.
Mm-hmm. Yeah. So just to provide some comfort as after raising that question, according to the Office of Civil Rights bulletin that gives guidance, the healthcare workers are supposed to do individualized assessments of each patient based on the best medical evidence. So I think there's this huge effort not to just categorically deny, oh, effective living will categorically denied, or most document categorically denied. I think that danger exists, but we do have some good, solid legal guidance that tries to avoid that. But just being aware of that as we move forward, because depending on what does happen, hopefully we're past those triage protocols being enacted, but if this does come back or whatever happens with this virus, being aware of what kind of exclusionary categories could be created.
Right.
Quickly then, I think I've tried to make the point that we really want to appoint that agent, whether we create that living will, that could be circumstantial, but really be sure that that agent is appointed and knows your wishes. But now we have this situation where people can't have visitors. And so if someone is in the hospital, even if they lack capacity and need an agent, those agents aren't able to go into the hospitals and be part of those informed discussions. So that causes a problem, I think, with decision making, but it also causes a problem. Let's say the patient doesn't lack capacity, but maybe they need their spouse there next to them in order to, help think clearly. I think if I was in the hospital at this situation at this time, I would definitely want my spouse there to talk through these major issues. But that can't happen right now. We can't have visitors. So how do we help our agents communicate? And I don't think that that's really a legal question as much as a unique to this time period question. How do we work with healthcare? How do we, if I've had agents call me up and say, hey, you made my parents, you drafted their documents and now I'm not able to be a part of this. What am I supposed to do? So even though it's not really a legal issue, I feel like we'll be asked about it. One thing that does give some guidance under the HIPAA protections, they've loosened their restrictions on protected health information. So medical facilities can FaceTime, they can Skype, Zoom with their patients via telemedicine. Then the question is there also an implied sort of waiver that they could FaceTime while they have conversations with their patient so that the spouse on FaceTime could listen? So those are some questions to consider legally. I think that that there's been an expansion of restrictions. How far they go, we don't really know. Tom, do you have any thoughts on this sort of black hole that's been created with this pandemic on how to help agents make decisions for our clients?
I think every situation is different, but I think one thing we typically don't do a good job of is telling our clients once they sign the estate planning documents that they can call us. I think they know to call us when someone passes away and we have to do a probate. But the clients won't necessarily know that it's appropriate to call the attorney and get advice and counsel unless you tell them that. So tell them that they can call and get advice with regards to healthcare decision making if the documents come into play before the person passes away.
Thank you. Any other, I know that we're at the end of time and I didn't leave any time for questions, I apologize, but Any other thoughts or ethical considerations at the end here with, representing clients, and now maybe the former client's spouse is calling you about decisions, for another client. Do you have any thoughts on that, Tom?
Right. So you do the documents for husband and wife, and then husband becomes incapacitated, and the wife calls you for advice in her role as his agent. That's not necessarily a disqualifying conflict of interest, but it can be. And so be aware of that and consider the particular circumstances and objectives and whether those interests are diverging in such a way that you have a conflict of interest.
Thank you. So Beth, do we have any questions? I know we're at our time limit. I'm available for a couple more minutes. Tom, I'm not sure if you are, but do we have any questions out there?
There is one question in the queue, and it is, what are your thoughts on adding a provision to a healthcare POA that limits an agent's ability to execute a most, except to the extent that it is consistent with the principal's living will? And do you feel that this would address the concern that an agent may alter a principal's living will by executing a most after the principal's incapacity?
Oh, that's a good question. So I'll take a shot at it, and then Tom, definitely jump in. So I actually think that instead of putting within our power of attorney sort of a limiting structure, we want to put an expanding structure and say that if a most is created, our agent is the only one that can create it. And then I want to advise my client that as you go, if you're 30 now, as you go through life, then have these conversations with your agent. Okay, now I'm 30, I want this. Now I'm 40, I want this. So that agent knows exactly what you want. Because if you have a living will and it's 20 years old, maybe you've had conversations with that agent and now they're different than your living will. So I think that if our clients are continuing to have conversations with their agent, then the best person to know what that client wants if the client becomes incapacitated. So going back to Tom's point, the best person to know what the client wants is the client, but if that client can't speak for themselves, then the best person is going to be the agent who's been well informed all along the way. So when we have I think we're still having a panel during the state bar, and we'll talk about and actually give some suggested language for a power of attorney. So to answer that excellent question, I don't think we want to limit our agent. I think we want to expand and very clearly identify our agent as the only person that can create the most. And then we want to very clearly have a conversation with our client saying, tell your agent what you want all the time, every change in life scenario. Tom?
I concur, and because I don't think you'll ever have a client that says, I never want any treatment in any circumstances. And so to the extent that you wanted to, for example, say no treatment, no how, no way, anyway, and then try to make that prevail over a nuanced situation where your agent is responding to what the doctor is recommending, I'm not sure that you can or you should. I agree.
Yeah, thanks for that question.
All right, and that is the only question in the queue. So I just want to say thank you to those who have attended today's presentation, and thank you, Cameo and Professor Simmons, for your expertise in this area. If you have any other questions after the presentation, you can feel free to email me. And Cameo and Professor Simmons, are you welcome to receive questions by email?
Yes, definitely.
Okay, great.
Sure.
Once you leave today's webinar, you will all receive a survey on the presentation. We'd appreciate it if you can complete that and provide any feedback. You'll also receive a follow-up email within 24 to 48 hours that will provide you with a link to view the recording of today's webinar, and we will make sure to provide the materials from today's presentation on the State Bar website as well. So on behalf of the State Bar of South Dakota, thank you again for joining us today, and I hope you all have an enjoyable Memorial Day weekend.
Thank you.
Thanks, Beth.